My mother-in-law looked at my 3-year-old daughter, my healthy, laughing, perfect 3-year-old daughter, and said, in the same tone you would use to discuss a disappointing meal, that she was the reason this family had no future. Not those exact words. People like her rarely use exact words. What she said was, "This house needs an heir, and you have failed to provide one." My daughter Sophie was sitting 3 feet away playing with building blocks. She was 3 years old. She did not understand what was being said. I understood every single word. 2 weeks later, my husband, the man I had been married to for 6 years, the man who had held my hand in the delivery room and cried when our daughters were born, handed me divorce papers. He did not meet my eyes when he gave them to me. He set them on the kitchen table and walked out of the room. The reason listed was irreconcilable differences. The real reason was written in the space between every line. In 6 years of marriage, I had given this family 2 daughters and no sons, and to the woman who ran that household, 2 daughters and no sons was a failure worth ending a marriage over. I signed nothing. I called no one that night. I sat at that kitchen table with those papers in front of me, and I looked at my daughter asleep in the next room, and I made a decision that I want to tell you about. I was not going to let this be the ending. My name is Claire. And what happened in that courtroom 14 months later is something the woman who said my daughter had no future is still living with today. Stay with me. Daniel and I met through mutual friends at a work event when I was 25. He was kind, funny, and had the specific quality of someone who listened when you spoke rather than simply waiting for their turn. We dated for 2 years before he proposed. I said yes without hesitation because by then I had seen enough of who he was to trust what we were building. I want to be clear about that because it matters for understanding everything that came after. This was not a complicated relationship in the beginning. I had chosen Daniel freely and completely. I had loved him, the version of Daniel that existed before his mother's voice became the loudest thing in the room. We were happy in the early years. Not perfectly happy, no marriage is, but genuinely, sustainably happy in the way that comes from 2 people who like each other, who make each other laugh, who have compatible values and enough shared ground to build on. We had our first daughter, Lily, at year 2. She was healthy and beautiful, and Daniel held her in the delivery room with a tenderness that I stored in my memory because I knew, even then, that I would want to be able to return to it. Margaret, my mother-in-law, had been a presence from the beginning. Not a warm one, but a manageable one. She had opinions about everything, how the household should be run, my cooking, the way I spent my time, the career I had maintained after Lily was born. These opinions were delivered with the particular authority of a woman who had raised a son and believed that having done so entitled her to significant influence over the woman he married. I managed it. Not perfectly, but well enough. I worked as an accountant at a mid-sized firm, and the professional life gave me a sphere that was entirely mine, a daily reminder that I existed outside of Margaret's assessment of me. The first comment about a son came when Lily was 4 months old. It was framed as a joke. I laughed at the right moment and did not think about it again for several weeks. By the time Lily was 18 months old, the comments were no longer jokes. By the time I was pregnant with my second daughter, a pregnancy that Margaret treated as an opportunity rather than a celebration, a chance for the family to finally get what it had not gotten the first time, the pressure had become something structural. Something in the walls of that house that I could feel but could not name. When Sophie was born healthy and beautiful and unmistakably a girl, the silence from Margaret lasted 3 days. Not grief. Calculation. I did not know then what she was calculating. I found out 14 months later in a courtroom. What Margaret did between Sophie's birth and the divorce papers was not a single dramatic act. It was a campaign. Slow, patient, and conducted with the particular skill of someone who had been managing her household and the people in it for 30 years. She began with Daniel. Not confrontationally, she was too intelligent for direct confrontation, which is easy to defend against. She worked through implication and repetition. Small comments delivered consistently over months. The family name, the property, the business that Richard had built and that needed someone to inherit it properly. What it meant for all of that to have no son. Daniel was not a weak man in the ways people usually mean when they say that. He was capable, professionally successful, and genuinely loving to his daughters in the moments when Margaret's voice was not the loudest thing in the room. But he had been raised by that voice. He had been shaped by it in ways that went deeper than he could easily examine. And when it told him, consistently and quietly month after month, that his family was incomplete, that he had a duty that was going unfulfilled, something in him that I could not reach began to shift. I noticed it before I named it. A distance in how he spoke to me, a deference to his mother in conversations where he had previously held his own ground. A quality in his silences that had not been there in the first 4 years of our marriage. I tried to talk to him, more than once, several careful conversations where I said, as clearly as I knew how, that I felt something changing and that I was worried about what was driving it. He said the right things each time. He said I was imagining it. He said his mother was difficult, but that was nothing new. He said he loved me and he loved our daughters. He said all of that and continued to drift in the direction Margaret was pulling him. The papers arrived on a Tuesday morning. Daniel put them on the kitchen table while I was making Sophie's breakfast. Our daughter was in her high chair eating toast. He set the papers down, said he was sorry, and left for work. I finished making Sophie's breakfast. I gave it to her. I watched her eat it. Then I picked up the papers and read every single word. The document was thorough. Margaret had involved a lawyer. I could tell from the language, from the structure, from the specific clauses about the marital property that had been Daniel's family home for 2 generations. The filing was designed to move quickly and to leave me with the minimum that the law required. What the document did not account for was that I was an accountant who had spent 6 years understanding exactly what that house and its associated assets were actually worth, and exactly which of those assets had been accumulated during our marriage, and exactly what the law said about the division of marital property regardless of which spouse's family had originally owned the land beneath it. I set the papers down. I called my mother. Helen answered on the second ring. I told her what had happened without managing my voice for her benefit because I did not have the energy to manage it and she would have known anyway. She did not say anything for a long moment. Then she said, "Are you sitting down?" I said yes. She said, "Good, stay sitting, I am coming." She arrived 2 hours later. She came in carrying a container of food because my mother's response to any crisis has always included feeding the person in crisis, which is one of the things I love most about her. She sat across from me at the kitchen table. She looked at the papers. She looked at Sophie, who was asleep by then in the next room. She looked at me, then she said something I have thought about many times since. She said, "Claire, I have spent my life making myself smaller so that other people would be more comfortable. I am not going to watch you do the same thing." She had her own history, a marriage that had asked more of her than it gave, a life that had required significant compromise of the kind that women of her generation were expected to make without complaint. She had made those compromises. She had never fully stopped carrying the weight of them. She was telling me as clearly as she knew how not to repeat her story. Then she said, "Who is the best lawyer you know of, not the most affordable?" The best? I told her I had one name. A woman named Diana Cross, who had been recommended to me by a colleague whose divorce case Diana had handled 2 years earlier. The colleague had described her as the kind of attorney who does not just understand the law but understands what a case means, who treats a legal argument as a story that needs to be told correctly. My mother said, "Call her in the morning." I called her in the morning. Diana Cross was 44 years old and had been practicing family law for 16 years. She was not warm in the way some lawyers perform warmth. She was direct, precise, and had the specific quality of someone who has seen enough human behavior in difficult circumstances to have calibrated her expectations without becoming cynical. She read the papers I brought her. She asked questions, careful, specific, not the questions of someone establishing sympathy but the questions of someone building a case. How long had we been married? What property existed at the time of marriage versus what had been accumulated since? What my income had been over the course of the marriage, what my documented contributions to the household had been. She asked about the real reason for the divorce. I told her everything, not just the irreconcilable differences on the papers, the actual reason, the comments about a son, the campaign, Margaret. Sophie sitting 3 feet away with her building blocks. Diana listened without expression. When I finished, she was quiet for a moment. Then she said, "What they have filed is legally thin. They are counting on speed and on the assumption that you will not have the resources or the knowledge to contest it properly. They are wrong on both counts as of today." She paused, then she said, "What I want to tell you is that we can do better than simply contesting this filing. We can make this case a precedent." I asked what she meant. She said, What was done to you, the documented campaign to end a marriage because a woman produced daughters rather than sons, is not just a personal wrong. It is a discriminatory act that the law has specific provisions to address. If we document it correctly and argue it correctly, we are not just fighting for your fair share of the marital assets. We are making an argument that has implications beyond your case. She looked at me directly. That argument will require you to go through this publicly and thoroughly. It will not be comfortable. I want to be honest with you about what it costs before you decide if it is what you want. I thought about Sophie, 3 years old, building blocks, completely unaware that someone had described her existence as a failure. I told Diana, I want to make the argument. The case Diana built over the following 6 months was the most thorough thing I have ever been part of, and I am an accountant, so thorough is my native language. We documented everything. Not just the divorce papers and the marital assets, everything. Every conversation I had a record of, text messages, emails. A journal I had kept, not deliberately as evidence but as a way of processing what I was living through, that turned out to contain dates and specific descriptions of incidents that became significant in the legal record. Witness statements came from people who had been present for Margaret's comments. A colleague who had attended a family event where Margaret had spoken publicly in terms that were specific enough to be documented. A neighbor. A close family friend who had been at the dinner where the air comment had been made with Sophie sitting 3 feet away playing with her blocks. Diana hired a forensic accountant. Not because she doubted my own analysis, but because a forensic accountant's findings carry different weight in court than a spouse's self-reported financial review. What that accountant found, going through 6 years of records, was that my contributions to the marital estate, both direct financial contributions and the economic value of domestic work and childcare that had allowed Daniel to focus entirely on his career, were significantly larger than the original filing had accounted for. The marital home was the central asset. Margaret's filing had argued that because it had been in Daniel's family for 2 generations, its current value should be treated primarily as family property rather than marital property. Diana's counterargument was detailed, specific, and built on 6 years of financial records showing exactly how our combined income and my management of the household had contributed to the property's maintenance and significantly increased value. The law in our state was clear, and Margaret's attorney, it became obvious during discovery, had not anticipated how thoroughly we could demonstrate it. Daniel called me once during the 6 months of case preparation. Not about the legal proceedings, his attorney had made clear that direct contact was inappropriate. He called my personal number on a Sunday evening, and when I answered he said simply, "I'm sorry, Claire." I said, "I know." He said, "I don't know how to fix this." I said, "You can't fix it from there, this is where we are now." We did not speak again until the courtroom. Chapter 6, Margaret's testimony, 15 o'clock to 18 o'clock. The hearing lasted 2 days. I want to tell you about the second day. Specifically about Margaret's testimony, because it is the part of this story I think about when I need to remember that truth, told clearly and specifically in the right setting, has a power that manipulation simply does not. Margaret had been composed throughout the first day. Well-dressed, controlled, with the bearing of someone who had decided that dignity was her best strategy, her attorney had prepared her carefully. She answered questions in ways that were technically accurate while being contextually misleading, the specific skill of someone who has been selectively honest for a very long time. Diana let the first day proceed without pressing hard. She was watching, building. On the second day, Diana cross-examined Margaret for 90 minutes. She began with simple questions, the timeline of events, the dates of specific conversations, the public statements that had been witnessed and carefully documented. Each question was precise and required a specific answer that Margaret could not meaningfully deflect, because the documentation Diana had built made deflection impossible. Then Diana asked about the building blocks. She asked Margaret to confirm that she had made the comment about the family needing an heir in my presence, in the family home, while my daughter was sitting in the same room. Margaret's attorney objected. The objection was overruled. Margaret confirmed it. She had no choice. 2 witnesses had provided sworn statements about that specific incident. Diana asked her to explain what she had meant. What Margaret said in response to that question, the explanation she gave, the justification she offered, The specific language she used to describe why a family with 2 daughters and no sons had no future, I will not repeat in full detail here. What I will tell you is that it was the kind of statement that sounds, in the specific setting of a courtroom, like someone has removed a filter and allowed something that usually lives in private to become fully, permanently visible in public. The room was very quiet when she finished. Diana let the quiet sit for a long moment. Then she said calmly, "No further questions." The judge issued her ruling 8 days after the hearing concluded. I want to give you the substance of what she found, not her exact words, but the core of her decision. She found that the marital assets had been incorrectly characterized in the original filing. She found that my financial and domestic contributions over 6 years of marriage had been materially undervalued. She found that the circumstances under which the divorce had been pursued, the documented campaign, the statements made by Margaret, the clear timeline connecting those statements directly to the filing, were fully relevant to the court's understanding of the situation and to its determination of what equitable distribution actually meant. She awarded me 58% of the marital estate, including a share of the family home's current value that reflected my documented contribution to its maintenance and appreciation over 6 years of marriage. She awarded me full primary custody of both Lily and Sophie, with structured visitation for Daniel. The custody determination was based on the totality of circumstances presented, including the documented family environment and the specific statements made during testimony about the value of daughters in that household. She awarded full legal costs to me. Diana shook my hand outside the courtroom afterward. She said simply, "You did that. The documentation, the preparation, the 2 days sitting in that room. That was you." I called my mother from the courthouse steps. Helen answered on the second ring. I told her the ruling. She was quiet for a moment, then she said, "Good, now come home. Sophie is asking for you. I want to tell you where everyone ended up because I think the honest accounting matters more than a tidy conclusion." Daniel did not contest the ruling. I think by the end of those 2 days in court, something in him had seen clearly what had happened, not just to me, but to his own choices, to the years of deferring to a voice that had cost him far more than he had understood it would. He has honored the custody arrangement completely. He is present with Lily and Sophie in the structured way the court determined, and from what I can observe, the time he spends with them is genuine. I do not know what his relationship with Margaret looks like now. It is not my business and I have not asked. Margaret has not spoken to me since the ruling. I did not expect she would. What she said in that courtroom became part of the public record of the case and has followed her in ways I did not engineer and did not need to. Diana told me about a year after the ruling that the case had been cited in 2 subsequent family law proceedings in our state involving similar circumstances. She mentioned it without drama, simply as information. I sat with it for a long time. I moved into an apartment with Lily and Sophie 3 months after the ruling. It is smaller than the house we had lived in, significantly smaller. Sophie called it cozy on the very first day in the specific way children name things accurately without meaning to. She was right. It is cozy. It is ours. Every corner of it reflects a choice I made rather than a compromise I quietly absorbed. I returned to full-time work. My employer had been more generous during the proceedings than I had felt I could ask for, and returning felt like stepping back into a version of myself that the last 2 years had interrupted but absolutely had not erased. My mother Helen moved closer. Not into our apartment. She is not a woman who moves into other people's spaces, but 20 minutes away rather than 2 hours. She comes every Sunday. She brings food. She sits on the floor with Sophie and builds things out of blocks. I have thought about that image many times since. My mother on the floor, building things, at an age and a stage of life where she is still showing her granddaughter that building is what you do. I have been thinking about this section since before I agreed to tell this story publicly. About what I actually want to say, not what sounds right, not what wraps this neatly, but what is genuinely true. Here is what I want Sophie to know when she is old enough to understand it. She will be told at some point in her life that her existence is less than it should be, that she is not the right version of something, that her value is conditional on characteristics she did not choose and cannot change. This is not a prediction. It is a near certainty, because the world contains people who believe these things and are not always careful about who hears them. When that happens, when someone looks at her the way her grandmother looked at her at 3 years old, with the specific dismissal of a person who has decided she is insufficient, I want her to remember that the response available to her is not silence and it is not explosion. It is documentation and preparation and finding the right people to stand beside her and walking into a room and telling the truth as specifically and completely as she can. That is what I did. It was not elegant. It was 14 months of the hardest sustained effort of my life. It cost me sleep and money and a marriage that had already been taken from me before I began fighting for what it had produced. But I did it. I stood in that courtroom and I told the truth, and the truth was enough. Sophie is 4 now. She still builds things with blocks. She builds them tall, taller than seems stable, taller than seems structurally possible, and when they fall she looks at them for just a moment and then she starts again. She did not learn that from me. She came to it entirely herself, but I recognize it, and I intend to spend the rest of her childhood making absolutely certain she never loses it. If you or someone you know is facing a situation where they are being told their worth is conditional on what they have produced, what they look like, what gender their children are, who they were born to, I want to say something directly. The law exists. It is imperfect and it is slow and it requires resources that are not always easily accessible. But it exists, and it has specific provisions for exactly these situations, and the most important first step is finding someone who knows how to use it properly on your behalf. Document everything, date it, keep it. The journal I wrote simply to process my own feelings became evidence in court. I did not know that when I was writing it. I know it now. And if you are sitting somewhere tonight feeling like what has been done to you is simply the way things are, please hear this clearly. What is done to you is not the same as what is possible for you. Those are two entirely different things, and the distance between them is exactly the size of what you decide to do next. Leave a comment below if this story meant something to you today. I read every single one. Next week, a woman who discovered on the morning of her 10-year work anniversary that her promotion had been quietly handed to someone else. What she built in the 90 days after that discovery changed her entire industry. Subscribe and turn on notifications. That story is next. Thank you for watching. I will see you in the next one.